My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan, so please subscribe to our channel. Does it matter if your ex won't sign your divorce papers? Well, probably not. It really depends on what divorce papers we're talking about. If, for example, the divorce papers that you're referring to are the first papers that you send and then you send an acknowledgement of service and they won't sign that they got them, it's not going to stop you. If they won't acknowledge that they received the papers, then there are certain things that you can file in the court to alternatively serve them if there are evading process, to file appropriate affidavits with the court that they have been served, that they did receive it, and if they don't want to sign the acknowledgement, the person who served them, that person will sign the acknowledgement. Now what about if you have a case, there's an order, the court puts proofs on the record, everything is done, you send papers to your ex, they won't sign them. Well, guess what? They don't have to sign them. If they refuse to sign something that's been put on the record, your lawyer will know how to file a petition and order under the 7-day rule, which will cause those papers to be filed and signed by the judge, irrespective of whether or not the other party signs them. So long as the order that you present to the court comports with what the court ruled, you don't need the other side's signature. Giving it to sign is a courtesy. If they don't want to avail themselves of that courtesy, file it under the 7-day rule. Your lawyer will know how to do that. There'll be a notice of presentment set up, and if they don't file appropriate objections within 7 days, the court signs it, and that's it. And the only basis for filing objections is if the order says something different than what the court approved. And if you file objections, and it turns out you filed frivolous objections because the order is exactly what the court ordered, guess what's going to happen? The court's going to sanction you. The court's going to find that you are responsible and maybe hold you for the attorney fees that the other side incurred in having to do all this. So you don't want to do that. Your best bet is if you don't want to sign something, you don't necessarily have to sign it. It'll go in under the 7-day rule. Don't file objections unless there's a basis for doing it. But does the other side need to sign? Not necessarily, because your lawyer has a court-ruled sanctioned workaround should the other side refuse to sign. If you have any questions about that, reach out and we'll be glad to help you out.